The COVID-19 pandemic may result in a delay or even termination of an ongoing M&A transaction. Let us address the first part of it, which is in relation to the delay of a transaction. The current transactions may be delayed for various reasons. Let us take one example. For instance, there are conditions precedent that provide that certain regulatory approvals need to be obtained or certain actions that are required to be taken by the company prior to achieving closing. That may be difficult under the current circumstances because the regulatory approvals may be difficult to come by considering the situation that the country is facing right now, and including any actions that are required to be taken by the company which may have bearing on a third party action which may be difficult to come by because of the lack of resources that exist during the current lockdown period. Having said that, the parties need to sort of perhaps revisit these requirements, and the acquirers could even consider having these conditions precedent translated into conditions subsequent to have the deal closure. Now, to address the second part vis-a-vis a termination situation in an M&A transaction, that could emanate from the fact considering the growing difficulties that may come about as a result of the current epidemic. The acquirer may choose to call out a material adverse change vis-a-vis the financials going forward of the company, and this may have a bearing on the deal closure as well. Having said that, a material adverse change is a significant call to make and would be determined on various factors such as the language of the clause, what it captures, and also would need to have close scrutiny as to the long-term effect that a material adverse change that is being sought to be called out has vis-a-vis the current transaction.